was right here and I didn't touch it.
I still like mine.
Is it in the trash?
He must have forgotten on his desk. On his desk,
It's on his desk, I think.
yeah.
What you got in there? No?
Classy.
Is that like a shopping list? Oh, is it in his bag?
I just feel like it might, you following it might be.
Now, I don't think so. No.
It's on his desk. I wonder.
Big cheap stuff.
Oh, he got it, he got it.
He got it,
he
he
got
Big cheap stuff.
He has it.
He has it in his bag.
It's above my pay grade.
I saw him around.
He's in his office breathing, I saw what he said. Did Commissioner Korea get his lunch?
Yes.
You got your lunch? The veggie wrap?
Thank you.
Okay, good.
I'm going to take it home and eat it. So thank you. I had some really like for embarrassment.
Yes.
Do you know Mike did, because he even said when he left, he said, yeah.
He must have done it.
Yeah, so he took it.
He probably is going to.
Just wonder.
I mean, that's a. You know, Good afternoon, everyone, and welcome to the Delaware Public Service Commission meeting of June 4th, 2019. We have on the first part of the agenda the public and executive session minutes of the May 7th meeting. Was there any changes or corrections to those documents? Commissioner Gray.
I move that the commission adopt those minutes, both executive and public, as submitted.
Second the motion?
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. May 21st, any changes, corrections? Commissioner Korea. Just trying to see if you're awake, Commissioner Korea.
I was moving my hand, so I was awake.
I know you were, that's why I called on you.
But thank you for waking me up.
Move we adopt the minutes of May 21st, 2019 as presented.
And I second.
Is there any discussion on that motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed, any abstentions? The motion carries.
Abstain. I was not here,
One
Chair.
abstention. You know what? This guy gets reappointed for 5 years and he doesn't show up at the first meeting. Congratulations, Commissioner Gray. It's great to hear that you're on board for 5 more years.
Thank you, Mr. Chair.
And thank you for your participation at the conference, which we all knew you were at, and that you weren't just willy-nilly missing the meeting.
Actually, I was in training for how to establish rates on gas, since I'm on the gas committee. So.
Terrific. There is the consent agenda, and we have 4 items on the consent agenda. Does any commissioner want any of those items off of the calendar? If not, if there's no objection to those matters, could we have a motion to approve the consent agenda?
Motion to approve the consent agenda as presented.
I seconded.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. I'm tempted to say we're adjourned just to see what reaction I'd get. But I just want to say before we get into the regular agenda, it's about the EV thing, and that is that I've read a lot about electric vehicles over the last few years, and all the parties, please come up. And we had a few documents that we were given to read in preparation for today. And I just want to say that, gosh, everyone who participated brought up just great ideas in defense of their positions or in opposition to a position. And so I just want to say thank you to all involved because, and then you guys came up with a settlement. So frankly, you guys did a great job. Everyone did a great job. So let's, before I go any further on that, let's hear from, I guess, Lindsay Orr. You're going to be the leader?
Thank you, Chair Winslow and Commissioners. Good afternoon. Lindsay Orr on behalf of Delmarva Power. On October 19th, 2017, Delmarva Power filed an application for a voluntary program for plug-in vehicle charging, which it then amended on February 9th, 2018. Delmarva filed this application because of the significant impact that the electrification of the transportation grid will have on Delmarva's customers and on the state as a whole. DPA intervened in this matter and staff also participated. Additionally, motions for intervention were approved for DENREC, Sierra Club, and Cesar Rodney Institute, and those entities participated in this docket as well. Public comment sessions were held in all 3 counties in January 2018. Notice of those public comment sessions was published in newspapers of general circulation in all 3 counties and was also reflected on the procedural schedule published on Delafile. Pursuant to the procedural schedule, the parties engaged in substantial discovery and also filed written testimony. I am pleased to report, as Chair Winslow just noted, that in January 2019, staff, DPA, and Delmarva Power finalized a settlement in this matter and submitted a proposed form of settlement agreement to the hearing examiner. The settlement contains the following terms. Until real-time pricing is allowed by state law, Delmarva may institute a new mandatory service classification applicable to second meters used solely to meter residential PIV charging usage. The new service classification will include a time-of-use standard offer service rate designed to encourage nighttime charging. Participants in this new mandatory service classification will have the option of receiving electricity consisting of 100% renewable energy in the form of a volumetric adder, PIV green. This adder will allow customers to have their energy supplied from 100% green energy and to claim zero tailpipe emissions when charging an all-electric vehicle. Delmarva may install 2 smart level 2 chargers in neighborhoods within Delmarva's Delaware service territory to be determined by Delmarva, staff, DPA, and DelDOT, and may institute a new service classification for the use of such chargers. Delmarva may also install 2 direct current fast chargers along main transportation corridor sites in Delmarva's Delaware service territory in locations, again, to be determined by Delmarva, staff, DPA, and DelDOT, and may institute a new service classification for the use of such chargers. In the case of both the neighborhood level 2 chargers and the direct current fast chargers, the equipment will be owned and maintained by Delmarva and will provide electricity through 100% renewable energy sources. The settlement also provides that Delmarva may record the costs incurred as a result of these offerings I just described as a regulatory asset. The company will seek recovery of the regulatory asset in its next base rate case, where the reasonableness and amount of the regulatory asset will be subject to review and challenge by any other party. Finally, the settlement establishes a working group consisting of representatives from Delmarva Power, staff, and DPA, with representatives of other state agencies such as DENREC and DelDOT participating where appropriate. This working group will meet quarterly to evaluate PIV issues, market conditions, and new offerings going forward. An evidentiary hearing on the settlement was held in front of Senior Hearing Examiner Mark Lawrence on February 28, 2019. Delmarva Power, staff, DPA, and Cesar Rodney Institute presented witnesses who testified that the settlement is in the public interest. The hearing examiner filed his findings and recommendations on April 11th, 2019, finding the settlement to be in the public interest and recommending its approval. Delmarva Power believes that its involvement in this space, as allowed by the proposed settlement, is in the public interest because it will help with long-term grid planning, which will accrue to the benefit of Delmarva's customers. Accordingly, Delmarva Power respectfully requests the Commission approve Order Number 9357, adopting the hearing examiner's findings and recommendations and approving the settlement in this docket. Thank you.
Thank you, Ms. Orr. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. The GPA obviously was a signatory to the settlement agreement, and so we do request that the Commission approve the settlement agreement. As often happens in settlement agreements, not every party gets everything that they want. I think that it's been said that the sign of a good settlement is that everybody's unhappy. I won't say that we're happy with it, but we signed it. Our exceptions, so to speak, were not with the hearing examiner's recommendation to approve the settlement agreement. Our exceptions go to it goes to, not the recommended decision, it goes to what's in it. And that is this. 1/3 of the recommended findings and decision is almost a verbatim transcription of the public comments that were submitted in writing to the Commission. We're not saying that public comment isn't important. It is. The Commission holds public comment sessions. The DPA attends those public comment sessions. But we raised the issue here because of a concern about the emphasis that the hearing examiner seemed to place on those public comments in this docket. As I said, it wasn't just a summary of the public comments that was included in the recommended decision. In some cases, it's a verbatim transcription of what those comments said. And the reason that we're concerned is because public comments are not evidence on which the hearing examiner or the Commission can base a recommended decision, or in this Commission's case, a final decision. The APA requires the Commission to make its determination based on the evidence received, and that's section 10122, subsection 6 of 29 Delaware Code. And the Commission itself acknowledges this requirement in every public notice in a case decision docket, including the one in this docket. Now, evidence consists of the sworn testimony and the documents that are entered into evidence at the evidentiary hearing. Public comments are neither sworn testimony nor documents entered into evidence at the evidentiary hearing. With the exception of Mr. Stevenson on behalf of CRI, none of the entities that submitted public comments intervened in this case. They didn't submit pre-filed testimony. They didn't appear at the evidentiary hearing. A party to a proceeding has a right to cross-examine adverse witnesses, but because the commenters weren't parties, no one was able to cross-examine them. And none of the entities that submitted comments is a party to the settlement. Now, in previous recommended decisions, the public comment has been briefly summarized, and that's appropriate. But if this detailed type of discussion of public comment is to be the template for future case decisions, as opposed to regulation dockets, we are concerned that the substance of the public comment may, either consciously or unconsciously, become a basis for the decision. And that is not appropriate because it isn't evidence. So we just wanted to bring this concern to the Commission's attention now. It's not as big a concern in this case because there's an uncontested settlement. But it could matter greatly in a case decision in the future where there's not a settlement or the settlement is contested. And just a couple of asides. First, one of the public comments that was summarized at length was submitted long after the Commission's imposed deadline for receiving written comment, and as such should not have been included in the first place. And secondly, with respect to, well, I should say, you'll see that I'm sure that what was included in your packages was comments from DENREC, which originally was a response to the DPA's comments. It has since redacted its submission to, I think, to remove the comment on what the DPA wrote after the executive director had advised it that comments on another party's comments are impermissible. You may recall the go-round we just had on that. So with that, we do ask that the commission enter the order approving the settlement, and thank you for your consideration.
Thank you very much, Ms. Iori. Mr. Walsh?
I do want to just jump in here advising the commission. I think what Ms. Iori said makes a lot of sense. Normally, the hearing examiner's report simply summarizes the evidence and then gives a decision based on the actual evidence presented. Summarizes the public testimony, I mean. And so it is a very valid point that she's raising. It's up to the commission whether to accept the hearing report as is or to make any changes to it that they want to. But okay, that's it.
Thank you, Mr. Willard.
Thank you, Chairman and Commissioners. Tom Walsh on behalf of staff. Just to clarify one thing that Mr. Willard mentioned, that is part of the key here. It wasn't public testimony. These are public comments. There was no testimony, and as Ms. Iori pointed out, it is critical to, when reaching the evidence hurdle, there must be an opportunity for cross-examination to vet that information, and there was a lot of information because of those public comments were included verbatim, about 16 pages. But getting ahead of myself a little bit, I want to, of course, staff was a signatory, and we believe this is a good settlement, and we, of course, ask that the commission approve the order, but as our exceptions noted, and without being redundant to anything Ms. Iori said, the inclusion of the public comments is a little bit, as I stated in my exceptions, adopting those pages is both anomalous and problematic. It's anomalous because it has no bearing on the findings, and that is stated in the hearing report itself. There is a standard of review that the Superior Court of Chancery and Delaware Supreme Court have long upheld that states that in terms of finding whether a decision is arbitrary and capricious or any part thereof, they review that decision to see if the agency has employed a decision-making process rationally designed to uncover and address the available facts and evidence that bear materially upon the issue being decided. Those 16 pages don't bear at all, let alone materially, and I think that's important. And if it were adopted, it then becomes problematic because it sets the stage for doing so in the future, and if that were the case, then that is the record that would be reviewed in any appeal, in any reconsideration, and I think that that is not the standard which the courts have asked the agencies and this commission to uphold. Again, that was not evidence, and without being so, particularly with the facts that were adduced in those public comments, I think it's critical to remove those. One thing I'd put in staff's exceptions was a citation to the Public Service Commission's Rules of Practice and Procedure, particularly Rule 1001-1.7.2, which states filings that allege facts not otherwise in the record must be accompanied by a sworn a signed sworn verification. Where the filer is a corporation or an association, the verification shall be signed by a bona fide officer thereof. That did not occur here, so I can't imagine why those facts would be included. I would suggest that if this were an evidentiary hearing and someone would try to put those forward, there would be good grounds to strike those on that basis alone. So, again, we support the settlement agreement as Ms. Orr set forth for the hearing, or for the commission, but the report itself, the inclusion of all the public comments doesn't seem to serve any legitimate purpose. Thank you.
Thank you, Mr. Walsh. Mr. Twiddle?
Yes, thank you, Commissioners. Jameson Tweedy on behalf of
Tweedy.
DENREC. I'll try and keep my comments brief. As you've heard, all parties are in favor of the settlement or do not oppose the settlement, so I think it's fair to say everyone is supportive of the Commission entering that settlement agreement and entering proposed order number 9357. The one point of disagreement you've heard is about the inclusion of public comments into the hearing examiner's report. DENREC believes strongly that the hearing examiner acted squarely within the authority delegated to him when he included public comment. I think I've heard counsel for the other parties indicate that they don't oppose the hearing examiner including summaries of public comment, just the manner in which he did it here, which I think is a very fine line to draw and would be very hard to enforce. DENREC also believes that robust inclusion of public comment is appropriate given the nature of the matters before this body and the various statutory and the rules within the Commission's own set of rules that encourage public comment, public notice, public participation. The hearing the delegation of authority to the hearing examiner originally included reference to public comment sessions and a full and complete record. That was clearly within the scope of his authority. And when he prepared his report, he was required to have a summary of the evidence that he considered. Now, I've heard that both Ms. Ioria and Mr. Walsh indicate that public comments somehow are problematic because they don't have an affidavit attached to them or are not subject to cross-examination. I think those would be very bizarre standards to apply to public comment, and both would significantly decrease the public's willingness to participate if either of those standards were put to public comments. Public comment is, or the involvement of the public is clearly within the scope of various PSC rules of practice and procedure, the PSC's governing statute, the Administrative Procedures Act. And so it's DENREC's view, and I'm happy to get into those further, that all of those things put what the hearing examiner did here squarely within the authority of the relevant law and the delegation of authority to him. As Ms. Iori mentioned, this commission had issued a decision in another matter about replies to exceptions, which I was not part of that docket. After being alerted to it, we redacted the letter that went to the commission so as to avoid those parts. I would be happy to discuss anything further if the commission needs it. Thank you.
Thank you, sir. Ms. Orr, do you have a comment to make about this issue?
I would just say that in a case such as this, which has been pending for some time and where an uncontested settlement has been reached, as I think Ms. Iori acknowledged, and all parties agree is in the public interest, Delmarva does not take issue with the hearing examiner's inclusion of public comments in its report. We would welcome clarification from the commission as to its preference with respect to how to handle public comments going forward, but we don't believe that that would prevent the commission from being able to enter or approve the settlement agreement in front of you today.
Thank you, Ms. Orr.
Again, Commissioners, I believe you certainly can honor the settlement agreement and approve it if you choose to. A couple of things that were just said. Mr. Tweedy mentioned about if cross-examination were allowed on public comments, people might not want to testify. I don't think that was their point. Their point was that you cannot cross-examine public comments. And so if the public comments are not part of the record and part of the evidence relied on, if you're going to make that part of that, it would be, you didn't have a chance to cross-examine it. I don't think they're saying you should be able to cross-examine it. They're just pointing out you can't cross-examine that. So if you have a whole lot of those public comments, not just summarized, but completely spelled out, you might not want to do that. So I think the commission can decide to let it stand as is, or to say that those comments should not have been included that way, they should only have been summarized. That's up to the commission.
Thank you, Mr. Willard.
Mr. Chairman,
Chairman
just to throw in, I support the position of the staff and the public advocate.
Thank you,
On this
Mr.
topic.
Stevenson. Can we just have a break in place just for a minute or two, please? I'd like to look something up. I guess I have a question or two. Mr. Willard, the document that we have in front of us is called Findings and Recommendations of the Hearing Examiner. And there's quite a few pages, and then at the very end, once again, if I recall correctly, has another document indicating findings and recommendations. And there, the hearing examiner goes into the specifics of the agreement, if I recall correctly. So, is there a distinction between, like what Denrick is suggesting, that the hearing examiner has the right, as a matter of fact, might be sort of by rules required to set forth the input from a variety of people according to public comments, but at the end, when he actually makes his findings and recommendations, if it's devoid of those, of a finding a basis but being those public comments, is that a distinction we can make here or not?
Yes, I think so. Again, generally, in these cases, it's my understanding anyway, that generally the public comments are simply briefly summarized, especially when they don't have a bearing on the final decision. Here they were not. Obviously, the recommendation and actual recommendation relies on the evidence presented by the parties and not the public comments. So I think you can separate the two and decide, if you wish, to say that the hearing report should be changed, but the settlement still stands, if you approve of the settlement.
Did I make myself clear, Ms. Iori? I'm sorry, it
I
seems.
think so. Let me take a stab at it, if I
Okay.
may. Frankly, I don't know what rules and regulations Denrick is referring to when they say your rules and regulations require you to take public comment in this manner. Chairman Winslow and Commissioner Conway, you have been seated up at those bench for a long time, and I would dare say that you would agree with me that this is the first time you've ever seen public comment included in proposed findings and recommendations to the extent that it has been here. It certainly has not been my experience, and I've been doing this a long time too. We are not saying that you should not take public comment. You do. And you attend them, we attend them, but I note that when the hearing examiners are conducting those public comment sessions, they give a little, kind of speech at the beginning to tell people what to expect. And one of the things that they tell people that are there is that the comments will be summarized and presented to the commission. 16 pages of a 65-page report, when I think there were perhaps 12 public comments or 12 public commenters, I would say is not simply a summarization. And as I explained, our concern is that facts that these commenters allege, and perhaps they did not do so here, but in another case down the road, could seep into the decision, unconsciously or consciously. And that is our concern with the level of detail that went into them here. DelDOT submitted public comments. I would have loved to have cross-examined DelDOT, but they weren't a party. ChargePoint submitted comments. I would have liked to have cross-examined them too, but they weren't a party. Yet they alleged facts, and that is the concern, that somehow, some way, there is going to be seepage. I think it's fine that the commission knows that, okay, here's what people supporting it said, and you can summarize that. Here's what people opposing it said, and you can summarize that. That's been done. It's not difficult. I could probably do it in a half hour. But our concern is that public comments that assert facts and that come from entities such as the University of Delaware, whose opinions might be given more weight than somebody who just says, I don't think that ratepayers should have to pay for electric vehicles, are going to carry more weight. That is the concern. I hope that answered your question, although I realize it was really long-winded.
Well, I guess my thought was that there was an extensive reference to the public comments. And however, there was a conclusionary part of the report indicating that the hearing examiner was agreeing with the settlement, settlement agreement for a variety of reasons which he set forth in the report, none of which relied upon public comments. So I guess what I'm trying to say is, isn't it appropriate, could it be appropriate for us to approve the report and the order based upon the understanding that we know that there was no evidence presented by the people who made public comment, and that the comments made by the hearing examiner were merely, what we ordinarily get, which is a recitation of what the public comments were. Although I confess they were pretty extensive. And
Well, Chairman Winslow, the commission can do whatever it wants.
no, I understand. I understand that, but I'm just trying to see if you believe it's appropriate to sort of bifurcate those comments in the initial part of the report from the actual findings of the hearing examiner. Wonder if that would sort of obviate your objection, but apparently it doesn't.
It doesn't really, but as I said, in this case, in this particular case, it doesn't make a whole lot of difference. Because as you said, it does not look like he relied on them in reaching his decision. But this was this was an uncontested settlement. In the future, there could be a contested settlement, or there could be, in litigation. And our concern is that if you let it go this time, the next time, what are we going to see? The time after that, what are we going to see? I guess what perhaps we DPA, I can't speak for anyone else, what we are looking for is, what does this commission think is appropriate with respect to public comment? It's not evidence. So, but in this particular report, it was treated as such. I do want to say the hearing examiner circulated a draft report to all the parties requesting their comments. We made this same comment to him, and he's the hearing examiner. He doesn't have to accept it. He obviously did not. But we are not raising it for the first time before you. We did raise it with the hearing examiner as well, and for those reasons.
Thank you. Commissioner Gray?
In what way were the public comments treated or relied on in the process of arriving at the settlement?
DPA didn't rely on them.
Commissioner Gray, they were not relied upon by the settling parties or the hearing examiner in approving the settlement.
DENREC was not party to the settlement or the settlement negotiations.
DPL?
I cannot recall relying on the public comments in negotiating the settlement agreement.
Thank you.
Mr. Stevenson?
I was not a party to the settlement. The only comment I would make, if you recall, the qualified fuel cell project tariff, there were 550 comments. If we set this precedent, would have made a rather long report for you to read.
Commissioners, if I may, there seems to be a real distinction being drawn between a summary of the evidence and the manner in which the hearing examiner summarized it here. And yet the objection seems to be that it's not part of the evidence. Neither is part of the evidence, and yet one is considered okay by staff and the DPA, and the other is not. What DENREC is saying, and to be clear, DENREC is not saying that it must be part of the hearing examiner's report, more that it is entirely appropriate for the hearing examiner, within the scope of his authority, to decide what he wants to put in his report, and that this is entirely consistent with that authority, and it's entirely consistent with the various rules and statutes that encourage public participation in the PSC process.
May I comment, Mr. Chair? My view is that if the settling parties have arrived at a settlement and did not violate the process of bringing the public comment into their decision-making, then we're talking the mechanics of the hearing examiner's report. And I tend to agree that the hearing examiner needs to have discretion, and maybe the record here will establish moving forward just the extent of what scope should actually show up in his summary in the future.
Commissioner Correa?
My thinking is that it is not a question of whether hearing examiner relied it or not. There is also a question of whether the attorneys, DPA and our attorneys, were able to cross-examine the public or the people who made the comments. So without that, including the full text here, will be like one-sided looking at the things. Now, if you put 4 pages summary, then it's an addendum to information. But if you put all the 16 pages and it becomes part of the complete report, 16 out of 65, then the vital part that was missed is that the lawyers were unable to cross-examine. And that for future is not a good precedent.
Chairman, may I add one comment?
Yes, sir.
Thank you. I think if you look at this, simplify this a little bit, consider 16 pages of the public comments. There were 4 pages of findings and recommendations which did not reference the public comments, and then 32 pages entitled Summary of Evidence, memorializing the parties' positions, again not referencing the public comments, and then put that against the backdrop of the standard, and that is whether that decision-making was rationally designed to address the available facts and evidence that bear materially upon the issue being decided. Again, they did not bear materially upon the issue being decided, yet 16 pages of a lot of detailed facts, I would dare say that would be closer to something you might see from an expert in some of these public comments, are included yet have no bearing and are not referenced in the findings and recommendations or the summary of evidence. That would seem to just render it unnecessary. I think about what a jurist told me once about submitting papers to the court. Include everything that's needed and nothing that is unneeded. And here we have 16 pages of unneeded.
So what is public comment, Mr. Walsh?
Public comment.
What sort of consideration are we supposed to give to public comment?
Well, I will answer that in tandem with addressing what Mr. Tweedy said. Neither, I will speak for staff, but I believe DPA feel the same way. Nothing in our exceptions is trying to dissuade public comment. We recognize the importance of public comment. And as noted, those public comments are going to be summarized. That's what the hearing examiner states to the public in the public comment sessions. But if you're going to put in, there's a level that has to be assessed, and looking at the circumstances, and when you have an EV case, and you're putting in public comments which are setting forth very technical research data and conclusions, I think you rise above public comments. And if you include those, you are opening the door to have an arena of evidence not relied upon yet, made part of this, it ties in this order, and it ties in the hearing examiner's findings and recommendations, and is out there, doesn't serve a rational purpose. It does not do any good. It can only potentially confuse the issues and open the door to arguments that no party can anticipate. And it doesn't, again, the settlement agreement has been shown to be in the public interest, and the hearing examiner set forth his bases for that. And the basis, nowhere were the public comments mentioned. So again, it comes back to, it's extra. It could have been summarized. 16 pages is not summary.
Mr. Tweedy?
I think,
What I'm trying to find out is, when we did the Blue Water Wind Offshore thing, it seemed like I got 1,000 pieces of public comment along with the record, which I went through page by page, and I didn't read because oftentimes it was like a copy of the one I had before me in my hand. But we read all those public comments, and so what weight, if any, do I give to a public comment? I mean, it sort of sounds like you can't rely upon a public comment because it's not, you can't cross-examine a public comment, et cetera. So I'm just trying to discover here
so, Your Honor, I think the point you made earlier about a distinction between the portion of the hearing examiner's report that summarized what he did and what information he collected, and the portion of the report that provides a recommendation and guidance to the commission is a very good one. There is an evidentiary process through which information gets the binding weight of evidence and can be cross-examined. But important to this process is also public comment. And the importance of that public comment is that the public has an opportunity to express their view on the issues before the commission. And both are important parts of your process. That does not mean that public comment meets the weight of evidence. That does not mean that it is subject to cross-examination, but they're both important pieces. DENREC's view is that the hearing examiner should have discretion to determine how he chooses to summarize the evidence, the information he collected in his report. That is what he did here. In other cases where there might be 1,000 public comments, verbatim inclusion of that probably does not make sense. But again, that is something that is appropriately within the discretion of the hearing examiner, who has a delegation of authority from the commission.
Final word, Ms. Iori.
Thank you, Chairman Winslow. At the end of the day, Chairman Winslow, it's the commission's order. It's not the hearing examiner's order. It's not the party's order. It's the commission's order. If the commission thinks that it should be included like that, fine, it's your order. And the parties will ultimately do with it what they will. In this case, nothing, because it's an uncontested settlement.
Well, in this case, I don't believe the findings and recommendations at the end do contain any reliance upon public comment. So is there a motion from our commissioners with respect to the order number, is it 9357?
Yeah.
Are we going to get to make
Right.
additional comments? I had some other comments beyond this
Well, I'm
topic,
sorry, excuse me. Yes, Mr. Stevenson, please.
if you don't mind. Spent a year and a half on this docket. I'd like 5 minutes.
Yeah, well, you know what, and I think you did a heck of a job, too.
Thank you.
I guess it wasn't cross-examined or whatever, but I thought you had a lot of salient points you made, and I appreciated the comments about Bloom, et cetera, and all that stuff I'm not considering. We're just gonna consider what's in the separation, not separation agreement, excuse me. Wrong court. It's a,
Yes, I actually probably spent 2 weeks on that report, which is now, it's put aside, along with the Gable Associates report. Those will come up again. I believe that Delmarva will be back within 2 years for another EV docket, and we'll discuss that topic then. My report will still be there and updated, and we'll get to hopefully discuss that in detail. My comments today are a little bit different. There were some good things about this docket and the settlement, and some bad things. So first, the good things. One, by my calculation, the financial request of Delmarva, the settlement only gives Delmarva about 25% of the dollars they originally requested, so I think that's a real positive. Secondly, what Delmarva has based this request for approval on is that this is a way to get more information on what EVs are going to do to the grid. And in a way, you're passing an experiment. And I think one of the, Delmarva will learn some things from this. Now, I have 3 things I think they should make sure they learn. One, will a time of use rate change charging behavior? Charging, how will it work to change so everybody's using off-peak times to charge? Secondly, how can the need for EV charging in multifamily housing be met equitably? And thirdly, can Delmarva cover the investment cost of installing DC fast chargers along main transportation corridors? We've seen some existing chargers in Delaware already are only being operated maybe 2% of the time. So can they make money at this? A third thing that's very positive that came out of this is the working group that's going to be established with the staff and the public advocate in Delmarva. I think that's absolutely critical because there is a nature of this that is experimental, and these folks need to be able to build on this. So, for example, one of the things we would hope that would come out of this is during the working group session, there needs to be a control base of knowledge of current charging behavior, which was not established in this docket, so it can be properly compared to the behavior after the time of use rate and after the chargers are built. There has to be a solid base, otherwise the experiment is useless. Chargers placed in multifamily neighborhoods should provide the answers on how equitably chargers can be shared. I got to tell you, I don't know how that's going to work. You got one charger and 3 people in a neighborhood with EVs. They all want to use them at the same time. Good on them. Have fun with that. I do have 2 things that I'm concerned about. The first one, in the settlement agreement, Ms. Orr mentioned the PIV adder, green adder. And the summary of that is the adder will allow customers to have their energy supplied from 100% green energy, claim zero tailpipe emissions when charging an all-electric vehicle. Well, as we established in the evidentiary hearing, and it's kind of obvious, whatever the system mix is at PJM is going to be the electrons that go into that electric vehicle. It's not going to be 100% green energy. Somebody's going to buy Rex and call it that. I just want it known that I don't want to be associated with that sham whatsoever, don't agree with it, and so the public knows that I'm not part of that. By the way, there's a app you might want to look at. It's called Electricity Map. Instantaneously gives the system mix at PJM. Right now, it's about 60% coal and natural gas. So there's no way that somebody's going to charge a car, no matter what sign you put on the pump, that they're getting 100% renewable energy. Enough with that. My primary concern, which we're going to have to address in a future docket, there's actually 26 regulated utilities around the country and in 16 states that have already approved similar dockets to this. First three were in California in 2016. They've all used the same arguments Delmarva made. In California, the first round in 2016, 12,500 public chargers were approved. Within 2 years, those utilities came back, they got approval for another 62,000 chargers. All of these utilities are coming back. The only growth market that the utilities see at the moment is EV electricity use. And separately from that, and it's very appropriate that the commission deal with the electric use, time of use rates, but the other part of that is getting into the charging business is actually a new business. Now, I'm an entrepreneur. You know, you guys have seen me here for a while, but I spent 25 years starting 6 businesses. I know as an entrepreneur, I'm not going to go up against Delmarva with guaranteed rates of return on capital, putting in chargers and start a private charging company to try to compete against them.
Oh, you should be more confident of yourself than that, Mr. Stevenson. You know, Delmarva is not as nimble and it doesn't necessarily have the expertise you do. I think that ChargePoint and other entrepreneurial outfits are going to do mighty fine, and I hope they do great, and we need them in the marketplace. But we also might need Delmarva here and there, too, to help out.
Well, the question is, if you've got a new business for Delmarva, the regulated utility was started specifically to give the regulated utilities a natural monopoly because it was ridiculous for 6 companies to build the same transmission, distribution, and generating equipment. In this case, you want the exact opposite outcome. You want duplication as much as possible. And I think you'll get more duplication without Delmarva, this being treated as a regulated utility. They should be using investor funds.
I want to clear, we don't want duplication either, Mr. Stevenson. Now, I will say this, I'm not going to get into discussion with you about the issues. I think you bring up good issues. The one thing that was in the Sierra report, which was not cross-examined and upon which I'm not relying, was the fact that they recommended a 2-year review of all these things by the commission, like meaning us 5 commissioners. The settling parties were much smarter. I shouldn't say smarter than the Sierra Club because that's pretty hard to do. But you came up with a You came up with a working group idea, which you mentioned, which I think is excellent because, you know, these points that you make, Mr. Stevenson, or which you said in your report, which I indicated was very well done and very thoughtful, are very important, and they really do need to be looked at. And Mr. Slater made great points. I mean, a lot of people make great points, and that's got to be examined as we go forward with a pretty clear eye about what's happening in the marketplace, et cetera. So I'll just say once again, I think everyone did really great work to bring out the issues in this matter, and it came, I think, to a good settlement. And as you pointed out, you cut down the amount of money that's going to be used for the program, so it's going to be a smaller program. And as we go forward, you'll be able to make those arguments because the settlement agreement allows you to do that. So we're in a place where I think it's a good place. And we'll see how these arguments roll out over time, what happens in the marketplace with EVs. But I do think we have to take this step, and I commend the parties for taking this step. because we have to get off, gotta get off on this march and start to do this examination, or we're gonna be behind the 8 ball. So that's my feelings. Commissioner Gray.
Thank you, Mr. Chair. I also commend the parties for, after reading through all of the documents that I had, I was a little surprised that you came to a settlement, and I was very pleased, in fact, that you did, so we didn't have to wrestle that out here in front of the commission. But I do have about a half a dozen questions. They're not very detailed in every case, and they may not be known, the answers today. They may come before the working group. Customers who buy their power through brokers, how will they be affected when this program goes into play on the residential time of use rates? Will they still be able to buy through brokers? Is that an answer that's known yet, or is that a working group answer?
May I have just a minute, Commissioner?
Yeah.
I don't believe I introduced, this is Rob Stewart, who was our witness in the case at the evidentiary hearing. I do not know the answer to your question. I don't know if he might.
Well, it could be a simple yes or no at this point, or we don't know.
I think I know. Which,
Well,
which is-
we'll yield first to Delmarva since they're bringing someone.
No, it's a third-party supply. Because of the second AMI meter requirement, then the second AMI meter is only gonna meter the charge for the vehicle. So whatever the primary meter is on, that service is still, that account is still whole. So the house is still on the primary meter, the car is on the secondary meter, which is the second AMI meter. So if they're third-party supplied, they can still participate in the program.
With the second meter, through the second meter as well, right? Okay, thank you. Second question. What methods or parameters will be used to select the neighborhoods for deployment of the 2 level 2 charging stations? So why not 3, 1 per county? I mean, that's going to be pretty tough to choose 2 neighborhoods, in my view. I don't know whose decision that's going to be. Maybe that's the working group.
That's the working group.
Okay, that's fair enough. It's not clear, and this goes to Mr. Stevenson's point, it's not clear what level of integration or partnership exists today or is intended between the utility program and lessons already learned from the commercial charging companies throughout Delaware. Do you intend to work in an integrated way to get that baseline established from folks who've been in this business already? Anybody? Is that the working group as well?
Commissioner Gray, I think that is the working group, but also in my testimony, I do have what data we know. It was in my testimony.
Okay, that's fair. This is for Delmarva, I believe. What level of maintenance and reliability will you guarantee at utility-owned chargers? Is that working group as well? I do hope
I'm told 100%.
Okay, perfect. We won't talk about the rate structures comparatively. I'm sure that the working group will work that out between the commercial chargers and the Delmarva or utility chargers. How frequently will Delmarva report progress and findings on this program for the commission? Has that been established yet?
For the commission, I don't think has been established. The working group is supposed to meet quarterly under the settlement agreement, but actually, there might be a provision that says we'll agree in the working group how frequently to report.
Okay, I would have a keen interest, maybe quarterly, or we'll work it out with the executive director.
Okay.
But I'd have a pretty keen interest to understand what some of the findings are as you go through the process.
Commissioner Gray, I believe that Connie McDowell will be on that committee.
Perfect.
And you can call Connie up and she will.
I've
give
got
you
your
plenty
number.
of facts.
Okay.
Well, and of course, the commission has the power to direct,
Yeah.
to request specific information. So
Well,
that's
let-
always within the commission's power. It doesn't have to be in the settlement agreement.
No, I agree, but we'll talk to Connie and figure something that makes sense. All right, one last question. The PSC doesn't have standing or the authority over highway tax matters. Should this commission inform those authorities about the need to address the loss of highway tax dollars due to lower gasoline demand?
Commissioner Gray, I'll take that bullet too. So that's for the legislature to decide, and we'll leave that matter there.
And if
Yeah.
you want to, Commissioner Gray, you're welcome to walk over to the legislature and ask them to pass some taxes and
Well-
see what the reaction, but you're the only one who can do it because you just got reappointed.
I better do it now, right? But I'm assuming that if the motive is to enable and accelerate electric transportation, that is clearly a consequence that we might start anticipating.
Commissioner Gray, I 100% agree with you that that has to be dealt with at some point. It won't be for the commission, though. It'll be for DelDOT and the legislature to decide.
Which order number are we on, Mr. Chair? I'd like to make a motion. I'd like to move that the commission adopt order number 9357 as
I
submitted.
second.
Any discussion on the motion to approve order 9357?
I have a question.
Commissioner Kuria.
Commissioner Gray, does your motion and your second, does it including all the 16 pages of the, like the one is agreement and one is this approval of the report? So does it include the complete report of the hearing examiner?
As submitted, yes.
And I second that.
Any further discussion? All those in favor signify by saying aye.
Aye.
Are there any opposed?
Yeah, oh, no.
Any abstentions? The motion carries. Thank you very much, everyone.
Thank you.
Thank you.
There's nothing on our hearing schedule. Is there anyone here from the public? Mr. Stewart stood up. Anybody here from the public that wishes to make any comment to the Public Service Commission? Mr. Brewer. Dr. Brewer.
Thank you, Mr. Chairman and Commissioners. Commissioner Gray, I believe I defer to you. You need a few minutes to make some comments.
Well, yes, I wanted two thank yous. First of all, I thank Governor Carney for his trust in reappointing me and look forward to working with my fellow commissioners and the other folks who show up at these hearings a couple of times a month. And I'd also like to thank Pepco Holdings and a group called the Precisionists. They partnered to put autistic workers in careers doing meaningful work. And there was a conference in Camden, New Jersey last week that focused on diversity in the utility workforce. And I must say that in a workshop that I moderated, this was an extremely well-received, very popular idea that was grasped by a number of other employers who kind of ran toward the PHI people to figure out how'd you make it work. So thank you very much for making them available. They did a fine job. Please pass that along. That's all I have. Thank you.
Thank you, Commissioner Gray. Just to, I think Donna is taking notes. The meeting was the National Utilities Diversity Council, and the meeting was held on May 30th in Camden, New Jersey. I'm not sure where I am after hearing all those discussions. There's a public comment session in PSC docket number 190054, weather normalization adjustment, Chesapeake Utilities Corporations, at 6 p.m. here today. I have just one item to bring to your attention. I'm not asking for approval, I just want to give you an update. There was and after I give my comments, I welcome Public Advocate Drew Slater to comment on this. There was a Senate Joint Resolution number 1 introduced on May 23rd, in which the General Assembly, and I quote, is directing the Delaware Public Service Commission to review the qualified fuel cell provider tariff with the goal of finding ways to mitigate the future burden on Delmarva Power ratepayers. Then it goes through all the whereases, and then it resolves that the PSC is authorized and directed to conduct a comprehensive review of the QFCP facilities and tariff, that is the Bloom tariff, to identify and evaluate any opinions that may be available to mitigate the burden of that tariff on Delmarva Power ratepayers. Drew and I both report to the same cabinet secretary, and anytime there is a piece of draft legislation, we are asked to provide comments to our cabinet secretary. The PSC staff, not the commission, is going to indicate that there is nothing that the commission can do on this piece of legislation or even on the Bloom tariff because it is a binding contract. And as you all know, having gone through this, and Mr. Stevenson knows this very well, it is between the state of Delaware and how the act was passed. And I'm going to actually pass the baton over to Mr. Slater because he'll express the numbers much better than I
Oh,
do.
my goodness.
Mr. Slater.
Thank you, Dr. Barua. So we do report to the same boss. I'll be very succinct and blunt because that's just how I am. This was obviously a horrible deal. Your hands were tied behind your back and your mouth was duct taped by DENREC and by the legislature. It's quite clear. I'm glad DENREC's still here. So you really didn't have a choice. Senate Joint Resolution 1 doesn't change that. All it does is it says you need to review something that you don't actually have the authority to review or change. It doesn't really make much sense that you have to try and change something that you can't actually change, or come up with ideas or ways to change something that you can't change. That belongs squarely with the legislature in coordination with DENREC to see if they want to, if there is a different way, a different mousetrap to fund this. But it shouldn't have been done on ratepayers' backs. Economic development should never be done on ratepayers' backs. It was. If you try and change it right now, the cost, as we saw in a previous docket, is somewhere between $400 and $500 million. I don't think Delmarva ratepayers want to pay $500 million tomorrow. So those will be my comments if this is ever heard in the legislature. Just to be very blunt, it's a really bad deal, but this joint resolution doesn't actually change anything. It asks you to look at something that you yourselves cannot actually change.
Just to very quickly make a correction, as our ombudsperson pointed out, for the record, it was introduced on May 31st, not May 23rd. And I think the time period that Drew mentions, it's in this draft legislation, is the commission gets a year to come up with a report to all members of the General Assembly and the governor after the enactment of this resolution. So I'm really not sure what different the result would be, other than saying, sure, go ahead, break the contract between Delmarva and Bloom, and just make sure that it's paid for, because the way we see it, and I'll leave it to contract lawyers to argue it, Bloom gets to collect everything.
I have a question with respect to that. Is it possible that legislation could be passed to develop more electricity users? In other words, right now, only Delmarva Power and Light customers are paying the Bloom charge?
So I'll try and address that. I don't think it should be on electric utilities, ratepayers at all, on any of them, because it's actually a regressive form of taxation. Instead, it should have been a progressive tax, which if the state wanted economic development, the state should have actually paid for it. That is progressive taxation as opposed to regressive taxation, where somebody making $4 an hour is paying this, well, actually, I guess it's like $8.25 now. Making $8.25 an hour pays the same as somebody that pays $400 an hour. I'll use my own personal example. I choose to have a very smart home and a lot of smart technology in my house. My usage is a lot less than the average person's usage. The average person's usage is going to pay more than I'm going to pay, but I may have more means to actually pay. It should have been a progressive tax. It should have never been on an electric utilities bill. And I would say that for any kind of economic development, because the worst part about it was there was no consumer protection or clawback put in here for ratepayers if something didn't work out. It was always, you're going to pay for it regardless.
I agree with you. Now, could you answer my question?
Yes, I'll try and answer your question. The numerically, yes, the burden on the Delmarva ratepayers may go down numerically because you're broadening the base by adding the other electric customers in the state, i.e., I'll just use as a group the DMEC customers and the Delaware Electric Co-op customers. So numerically, the Delmarva customers will go down, but I'm a municipal customer, so my neighbors will say, why are we paying for this? And therefore, you should look at it. I'm naive politically, but my political experts will.
This is the point, right? It was not a great deal to begin with. We now see that it was not a great deal. So how are you going to then put it on everybody else? Because no one else wants this.
And didn't we just have an argument at the FERC that we shouldn't pay if there's really no benefit?
Yes, and that's the FERC argument too, that there is a lot of things written about, in fact, even in Congress, where the states' rights are, FERC is being chastised for stepping on states' rights through PJM, et cetera, and, there are various viewpoints on those things. So it's the same analogy, actually.
Well, there is a way. I mean, since this was economic development that was supposed to benefit all Delawareans, there is a way to do it. It's just not a politically palatable way to do it. And that is to, instead of having it be something that only Delmarva ratepayers pay, is to have a tax for it. But that will never pass the legislature, nor will requiring DEC and DMEC to buy any of this output and then to make their ratepayers responsible for it. That won't fly either.
Well, I happen to agree 100% with everything you said and also what Drew said. But why can't the secretary be told some of the political things and asked, why does this have to pass as a resolution? It really isn't, what good is this resolution doing either the Senate, the House, or the governor?
Yeah, so this is my point, right? The joint resolution itself doesn't make any sense. And really, if they wanted to look at it, it's the legislature themselves that should look at it. It's not something that you have that ability to do.
Yeah. Well, I think whoever the authors are intended well, but perhaps the secretary should be informed of some of the negatives of having it on the floor and discussing it on the floor, because this doesn't seem to be productive.
It opens up a nice can of worms in June.
Okay, anything else?
Yeah, the only thing I'm surprised at is, Mr. Slater, I didn't know you made that $400 an hour. Maybe I ought to go for a different opportunity.
$400 an hour. I don't.
You were talking about folks that made $4 an hour and.
Oh, I said $8.25, but then you have somebody that's going to make $400 an hour, and it's not. They're going to end up paying the same amount or less. I do not make $400 an hour. It's not me. It's not my teaching wife either.
It's his wife.
Okay, we're adjourned. Thank you very much.
Thank you.